Here's an interesting trending topic. What is the deal with digital wills? I'm Valerie Zammitti of Zammitti Law, an estate planning attorney in New York and New Jersey. And we provide peace of mind to families through our high client value estate planning and administration services. If you're seeking assistance in either of these in New York or New Jersey, you can reach us for a free consultation at yourplanningattorney.com. That's yourplanningattorney.com. And speaking of value, we are here to educate everyone for free. So please ask your questions and share so together we can help some folks along the way. Right now, there are about 15 states that have enacted some type of law allowing electronic wills, but the requirements really do vary across them. And this is what I call the tangled web we weave, at least the online web, that is. All jokes aside, in some places, the witnesses can be remote, and in others, they still have to physically be there, right? Some states require what's called a qualified custodian. I don't even know what that is. They have to hold your digital will, right? Seems insane, right? It's like a database somewhere. Well, enter another annual subscription fee. Seems frustrating to me, and I get it. It'd be nice to do everything remote. Human interaction, though, can't go away completely. Plus, it does create more complexity and things that you have to think about. All estate planning pieces need to be carefully drafted and signed to meet state requirements, right? Even with the additional option of digitally signing in some states, you have to be certain it gets done correctly, especially with the last will and testament, which historically has had like the highest scrutiny and requirements because it is going through the court process and it's not validated until after you're gone. And that's assuming there's no objection by the folks who would be your legal beneficiaries according to state law, had there not been a plan at all. And so, plug for all the estate planning attorneys out there. I've seen what DIY can do, what they produce, and that fact that they don't get executed properly, there's no guidance. It's really, really, really not in your best interest to go that route. You need the assistance. Yes, it can be broken down, but unless you're doing this every day, we all have a role in that for a reason, right? We wouldn't all still be out there. There's many of us. Anyway, I suggest it highly. Further, what happens if you move out of state? Where if you currently live in a state that is allowed to do electronic wills, but the new state does not, or they have different, totally different requirements. There are attorneys out there that say your written will that's been physically signed is going to be accepted in another state if you move. While this is true based on the Constitution, technically, full faith and credit clause, if you're interested, it doesn't mean that it's going to be as smooth as if, as a process for your family, as if you had just updated it to meet the exact state requirements when you move. And that's typically what we suggest, right? You want to make it as easy for everyone. For certain, though, there really right now is no explicit requirements for the court in the new state where you've moved to provide reciprocity with an electronic will. As such, you really would have to get a new will to, in the new state in that situation. Again, I'm Valerie Zammitti of Zammitti Law, an estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our high client value estate planning and probate administration services. You can reach us at yourplanningattorney.com. And we hope you've learned something new here today. Please don't forget to share and take care.